even what we're going to discuss in this video, the most emphasis on this video, we're going to discuss, what do you record to get on the record system or the deed system, because we already know that in most cases they're not going to record your claim of a sign under the original land patent. And you may then wonder, well, how can I use this? Why would I perfect this claim and it's a superior claim of title if I can't record it? So that's what we're going to address today. We're going to address how do you get on the deed. And I'll tell you the answer to that question, according to my research. What I think the best thing to do is you record an acceptable deed on the record, and within the contents of that deed, you reference the UCC filing. You have to watch the last video that I did before this video, because in that video when we talk about perfecting the land patent title, we talked about recording it behind the UCC. I never really got into the full details of that, but I suspect that if you have a membership with our website, when you log in, an example of that document will also be there of how it will be done. If it's not there, it's coming. So the reason for that is because the land patent doesn't go on a public record. It goes on your private record. It's a superior claim. The government is using basically the public record for documents that they have the superior claim to. So you put an acceptable deed there as a notice, and then you reference the land patent, which is on your private record behind the UCC. This will make more sense when we get into the actual templates part. We're going to do that next, but I'm laying it out and explaining it to you first. Now, when you're looking at the system, I'm going to call it the tenure system. That's not really what it's called, but that's what I'm going to refer to it as. And I'm talking about the system of when you go down to your county recorder and they have grant deeds and warranty deeds and those places where you go record deeds. They are, what was I going to mention about them? Okay, they are dealing with junior titles, right? And you still have to address the matter of the clear chain of title as far as even on their records, whether it's from grantor to grantee, from grantor to grantee. So it used to be that people would bring in warranty deeds when they're perfecting a private process. They'll bring in a warranty deed or a grant deed or even a quitclaim deed. And I'm hearing more so and finding out today that more of these documents are being rejected, and they're giving you different reasons of why such deeds are no longer applicable or no longer acceptable when you record them. They have to go through their official real estate chains. Now, that's not necessarily the law, but many of you who have went through and attempted to do these things, you're seeing more so and more so that you're being met with resistance. It'd be beyond the scope of this for me to imagine each different scenario and explain why you're being met with resistance. But usually it's dealing with how the county is perceiving the clear chain of title, and they basically are making a determination many times that you're just some belligerent coming in, interfering in the record, and that you don't really have a proper claim of a sign or anything like that. So you will see how we lay out in this process that we're going to talk about, which is a private process. We're going to perfect a private process, which we refer to as a writ of waste, which will levy against the prior tenants, and that the perfection of that private process is going to give us the proper cause of action to make an entry in the record, which means to record the proper deed that's going to put us on the record as the grantee or the owner of the property, at least as far as that system is concerned. And we're going to do that by way of the writ of waste, again, which is going to be a private process that's perfected, levied against the prior tenants, and recorded behind our UCC. and then based off of that private record, it's going to give us the authority to record, or it's going to give us the basis and the grounds for recording a deed that's called a non-acceptance of deed. The purpose of the non-acceptance of deed is it is an actual, I'm getting tongue-tied. The purpose of the non-acceptance of deed in our case is that it is an acceptable deed to record in the county that transfers and causes the indexing to shift to put us in the record of indexing as the owner as we should be. Okay, so this is the solution to not being able to record the superior claim of land patent title, or for not even being able to record the writ of waste, which are private perfected processes that are superior title. You reference them in an acceptable deed. In our example, our deed is a non-acceptance of deed. Let me Google this so you can see what I'm talking about. And I'm doing this on the fly because I don't even know what this is going to turn up. But let me Google non-acceptance of deed. As you see, there's a lot of things that pop up here. California Civil Code. A notice of non-acceptance of recorded deed executed by a holder of a security interest. Can you see that? I'm not clicking on any of these. I'm just showing you that this is something. So this is maybe something that you should research. Let me look at that right here though. Let's read this under California Civil Code. They say a notice of a non-acceptance of a recorded deed executed by a holder of a security interest. You know, in your case, if you're doing work on vacant, abandoned, commercial, residential, whatever property, and you acquire a security interest based off of the labor or the lien right, you're now a holder of a security interest. So I'm just trying to give you an understanding of what these words mean, but you got to look these words up yourself to see if it's applicable to your situation, right? We created a security interest because we did work to restore a property back to what it should have, you know, how it should have been held. You know, we removed waste and destruction and debris from the property that should not have been there. So we acquired a lien right or an interest. We became a security interest holder throughout the duration of our operations or our transaction or whatever you want to call it, right? But just reading what a non-acceptance of a recorded deed is. Now, this is an actual deed itself, okay? A notice of a non-acceptance of a recorded deed executed by a holder of a security interest, which notice identifies the security interest. This would be the warranty deed or the grantee deed, whatever security interest that deed is not accepting. So it identifies the security interest, contains a legal description of the property. Of course, it has to contain the legal description of the relevant property, the real estate. Identifies the parties to the deed, the original parties on the grant deed or the warranty deed, the date it was recorded, the county in which the project is located, and the county assessor's parcel number of the real property referenced in the deed may be recorded in the office of the county recorder where the real property is located. So I'm just showing you that that is a real thing. Now I'm going to bring it all together. So let me take a sip of water here, and we're going to log into the website. And we're going to look at the completion and the perfection of the land patent title claim, which is really already perfected and complete. But we're going to look at how we get on the record with our superior claim of title with, you know, with the situation of not being able to record the land patent down at the county. But remember, at this point, the land patent is already behind the UCC. You have to watch the previous video first, and I mentioned that at the end of the video. Many of you know how to file, you know, record property or security interest behind the UCC. If not, you have to learn or just review the example and just kind of backward study and learn. So first things first is let's log into the website here. And when we get into the website, we want to scroll down until we get to the advanced topics menu and click land and property acquisition. The first thing it begins to talk about here is the claim of original land patent, the claim of an assign. That's what I was talking about. That's the prerequisite video. You see it right here on the screen. All you have to do is click it and watch it. And when you watch that video, the first thing you have to do is go order your original land patent. Make sure you make your proper claim, publish it for 4 weeks, and do your affidavit of non-response. All the templates are in here right now, or they will be in here. You know, I'm always in the background putting them in here. Sometimes it just takes me time to get to it. And this is what we're talking about right now. Now I'm going to scroll down and I want to show you, this is what we just read. Let me get this into the middle of the screen here. This is the non-acceptance of deed. This is out of the indexing and recording manual, at least for here from California. You might want to find the similar manual in the state where you are. It gives you an example of every type of deed, affidavit, any type of deed, notice, trust document, surety bond, whatever type of record can be recorded in a county recorder. It gives them an example of each document, the requirements for each document, and it also gives them a citation to cite the actual codes. For example, what we're looking at on the screen here, this is an example, a page. Let's see, page number 233 out of that guide. It's an index photocopy of the page. And you notice here that this particular document, which we're going to record, this particular deed is called a notice of non-acceptance of a recorded deed. Now, I want you to pay attention to the indexing part, because from the county's perspective, the person who's receiving your documents, they have to do an indexing. And irregardless of what type of document you give them, they're going to be indexing who the new grantor is or who the old grantor is and who the grantee is. The grantee in their system, under this tenure system, is considered the new quote-unquote owner or responsible party for the property, the new tenant, if you will. But from the general public standpoint of view, that's the owner of the property. Based on the document that you give them, it will determine who the grantor or the grantee is. So for example, if I can zoom into here so you can see it, on this particular non-acceptance of deed document, the grantor is the person signing or the beneficiary. The person signing, if you look on this example over here, they're showing you the person signing is the security interest holder, right? So in this scenario of an acquisition, you are doing the acquisition, you are now the security interest holder, you are the person signing. So in the example of this notice of non-acceptance of a recorded deed, which is a deed within itself, the way that it gets indexed, you become the grantor because you're signing as the beneficiary. Usually, for example, on a quitclaim deed, this is where people have problems, because when the recorder looks in the indexing, they realize that there's a warranty deed that precedes your quitclaim deed. And in that warranty deed, there's a different party named as the grantee. So oftentimes people come in with the quitclaim deed that isn't conveyed from the grantee of the previous warranty deed or grant deed. So what that means is it's an interruption in the chain of title from the standpoint that they're looking at it. That is probably sometimes the reason why they deny recording certain types of deeds that you bring in when you're doing your private or your laid out administrative process for a property acquisition. Now, what you notice in this particular deed is, if you pay close attention, in this indexing, the grantor and the grantee are the same person, right? If you notice here, it says the grantee, zoom in, the grantee is the grantor from the deed in lieu. So the grantor is the person signing as the beneficiary. The person who is non-accepting the previous deed becomes the grantor and the grantee in the indexing of this properly recorded deed. So now let's look down here and better understand what makes this a properly recorded deed, because you know they're going to probably scrutinize it. And this is why we use the indexing and recording manual as a reference. Of course, you can just also use the California Code, as we looked at right here. California Code Civil Section 1058.5, that defines what a non-acceptance of deed looks like, or what the requirements of it is supposed to be. But also in their indexing and recording manual, you see that same code down here where it says legal references. These are the citations of authority for this deed, the same one we just looked at. And then there's another one. There's the California Civil Code 1058.5, and then we did look at the Government Code 27875, but that just deals with the acknowledgement. What is the acknowledgement? Scroll up here. If you look over here on the example document, notice of non-acceptance of deed, this is what an example would look like. Down at the bottom, appropriate acknowledgement. This is just the Government Code that talks about the acknowledgement. But this was all pulled out the Civil Code, and these are the requisites of that deed. These are the things that must be included, or they're going to reject the deed. So it has to have the name of the holder of the security interest. That is the new owner, the claimant under the land patent title. You know, the holder of the security interest levied by the writ of waste. We're going to talk about that in a second. The description of the security interest. What is the security interest? Did you gain the security interest? Is it your land patent process? Is it your writ of waste? The description of the security interest, in the example, they want you to provide a page and a book number, right? In our example, this description of the security interest, the description of security interest, you may say one or two sentences about it, and this is where you're going to reference your UCC number, where your private instruments are already recorded, where your claim of a sign under the original land patent perfected claim is recorded, and where your writ of waste has been perfected and levied against the prior tenants who abandoned the property and permitted waste on the property. So, but you won't get into that. You won't get into that whole thing. You may say a line about it, and you reference where the security interest can be outlined, which is behind your UCC. So you want to previously have the UCC filed, and that's where, and this is what it's all about right here. Referencing the UCC where the perfected claims are. Everything else, the date of recordation of the deed, identifying the previous deed. Now, the previous deed that you're doing the non-acceptance of, you look at it in the mindset that you're doing a cancellation of the previous deed because it is void, it is no longer valid. That's not the basis, but I'm just saying this is what you're doing. So this is why you have to understand what the habendum clause is, or whatever it stands for. And so you can look that up. And I'm going to show you where to look that up later on in this video. I have a colleague who's written about that. But you can just look in a law dictionary under the definition of to, or look in one of the old law dictionaries and find out what it means, the definition to have and to hold. And you'll realize that under the patent title system, when they grant it to these landowners, and under the warranty deed and the grant deed system, they're always giving the land to have and to hold. They're doing it under a tenure system, right? So they're establishing a tenancy. As a tenant, you cannot permit waste on the land. As a tenant, the term tenure means the conditions, how you're supposed to hold title to the land. Are you supposed to be producing on the land? Are you supposed to be cultivating the land? But you're not allowed to permit destructive waste and what do they call it? Chemicals and all type of stuff. You're not supposed to let that occur on land. That is a violation of the tenure. It's a violation of your how you're supposed to be holding title under any type of grant deed. Therefore, and plus this person has already vacated, abandoned the property anyway. So we pursue this by the writ of waste. Now, you have to look up the term waste. Waste has a legal and lawful significance. There are certain elements that constitute waste, and waste is a violation of tenure that can result in a forfeiture. So we set up our private administrative process, which is a writ of waste. Let's look at it. Actually, it's at the top of here. Wait, before I move to the writ of waste, let's see, that's it for the non-acceptance of deed. So again, we use the indexing and recording manual because we don't want them arguing about, well, I ain't never seen this before and you can't record it. Excuse me. This comes right out of their manual. It's an example of what it looks like. And if you look up here, here's my example of what it looks like. This is exactly what theirs looks like with just a slight bit of tweaking. Right? The non-acceptance of deed, you identify the deed that you're doing the non-acceptance of, you identify the grantor, you identify your security interest, which is your writ of waste or your superior claim of title. You identify where they can find the information, which is under the your UCC filing, your private record, because those are superior claims and they're your private property, your private records. And then you sign this non-acceptance of a recorded deed notice because it's a deed within itself, and that is why it's required to be acknowledged, as we've seen in the indexing recording manual, and then it's ready for recording. Now, back to the writ of waste. I just went on and downloaded the form and brought it up in full screen so you can see it better. Now, the writ of waste. Obviously, when you are dealing with your county recorder, they're not dealing with writs and things of the such. So a writ is a private process, and we perfect it as a private process. But the reason why we have to go through it, you may say it's a formality, but it actually gives us the cause of action for forfeiting the tenure of the tenants who abandoned and vacated the property and permitted the waste in the first place. So you have to look up what waste actually is because it's a violation of tenure. And the tenant received the property under tenure, we know, because on their deed it says to have and to hold, which doesn't grant allodial title, doesn't grant allodial rights. And as a tenant, they're supposed to produce on the land, whether to run a business on the land and make money on the land, or whether to cultivate the land. Permitting waste on the land is a violation of tenure. And because they don't intend to correct the problem, and they don't intend to pay you for correcting the problem or removing the waste from the premise, then as an operation of your process, they forfeit the tenancy and you hold the right and the title. That is the underlying cause of action that is perfected by the writ of waste, which also will get recorded behind the same UCC as the perfected claim of a sign under the original land patent. So just browsing over the writ of waste form real quick, you don't copy this if you don't understand everything in it. You don't need a tracer flag on this. I have my tracer flag on here for a reason, because of certain things that I'm doing. But if you understand it, then you can use it. If not, don't do things that you don't understand, because it's not going to work for you that way. As you see, everything is a part of something else, right? So, but there's a tracer flag on here. It's beyond the scope of this to go into what that is. There's a claimant, which is the person who's going to be doing the work on the property, because once you observe the waste and you see that the waste is permitting, you giving them notice to either remove the waste or to compensate you for removing the waste and restoring the property. And that is the interest, because essentially the reason why you're doing this is because you don't want to begin doing work on a vacant or abandoned property and not be able to protect the actual labor and the equity that you put in the property. You do $50,000 work in the property, and then somebody shows up after you even cleaned it up and did everything, saying, "Oh, by the way, that's mine." You want to make sure that you have a properly perfected claim against the prior tenants or anyone who's showing up with an interest on their behalf. So this is why you lay out the waste that's being permitted in the affidavit, and somewhere along you have a bill or the fee schedule that's attached of what it costs or what it has cost already for you to restore the premise. And so if you notice here, I have demolition of rotting and damaged structures and fixtures, removal of drug paraphernalia, gasoline, removal of hazardous materials, removal, so different things, securing the building, adding doors, removing debris from the public easement. All of these different things they make up the bill that you're using basically to protect yourself. And another way, you may just say, "Oh, I'm going to go file a mechanics lien." You could do that too. That's a weaker process, but you can also do that. But you lay out your bill and you serve it to the last tenants. So I'm going to lay this out. Now, when you look up the writ of waste, it is an actual cause of action, but there is no specific form. So I created this form. And this is where you have to do your own research a little bit. As a Moorish American, I have access to what you could consider a court. If you look up at the definition of a court, remember, a writ is issued by a court, or an administrative body. So you have to keep these things in your mind when you are designing or outlining your process or your procedure. So you have to look up every single word in the Bouvier's Law Dictionary, the Black's Law Dictionary, so that you can make sure your procedure is applicable. Don't just go ahead and copy this, not taking the fact that we're executing a writ into consideration. Can you lawfully execute a writ? I'm not saying that you can or you can't, but these are not the questions for me to answer for you. I'm saying be conscious of what you're doing. And again, we don't intend to record this writ in the county. This is a private record that gives us the cause of action for the non-acceptance of deed. This is a private record demonstrating that we levy a writ of waste against the owners for violating the tenure of the land. We consider ourselves heirs. And it doesn't matter, heirs or no heirs, you can't permit waste on a property. It's a violation of the law. And then they further abandoned the property, which is another violation. So they abandoned it and they permitted waste. So we restored the property and we recorded a lien against the prior tenants. This will protect us while we do everything else that we have to do to perfect the title. Now, once all of this is recorded behind the UCC, oh, by the way, let me point out this. The way this is set up, it's an affidavit in support of a writ of waste. I, as the laborer or the person doing the work, the person executing the process, I am the reporter. I am stating the facts. So I am laying out the process. This is an affidavit in support of the writ. But the writ is actually issued by the body of the court with the authority to do so. In this particular case, the authority will be granted by my grand sheet, and we'll apply seals to the document. But first, you see I have the registered mail number up here and the tracer flag, and with that registered mail number, I will send it to the last address for the previous tenants. I would get that off of the tax records or the grant deed or whatever. That's the tenants that are in violation that are permitting waste on the property. You could usually expect that this will be returned by registered mail, or it won't be properly responded to, because in this scenario, the property is vacated and abandoned. But to do the due process, I send off that writ, registered mail or certified mail, so it's trackable, and I sign it. I don't fill out any of this. This is what I fill out after my 14 days, after my process has ran and I have received no response, and the perfection of the claim completes. So after 14 days, or the mail gets returned or whatever, let's first read it. This affidavit of record supports the writ of waste to issue upon the above tenants for averment of tenure by abandonment and permitting waste, degradation, feces, dangerous drug paraphernalia, exposed rotted wood, and other harmful substances in relation to the property under tenure as relates to grant deed number whatever. I already named the deed that we're going after, which is demonstrating who the tenants are. So everything in this record, of course, goes out of the requisites and the document that we looked at earlier, out of the indexing and recording manual. So the last part of the instrument, notice how I keep it real precise to one page. I no longer feel compelled to start adding all of the private stuff that I did in the land patent. None of that stuff is relevant at this point of the game. This is just something I learned over time. You keep everything short and precise. The UCC is referenced in the non-acceptance of deed. It's no need to start repeating and regurgitating all that stuff. Keep it one page to the point, because then it's likely that it's actually going to be read. The claimants therefore require satisfaction in accord for repairs, restoring, and preservation as set forth in the enclosed bill within 14 days in lieu of default. The failure to respond or satisfy the attached bill within 30 days shall accelerate the passage of title in the land, divesting the tenants from the estate and vesting it in the MDAO trust. So you get an idea of what this process is supposed to do in the event that there is no response or that there is a default. So then 14 days go by, you sign it, there's no response, or it gets returned in the mail. Then you come and you sign this little affirmation that I put down here, and that is where your administrative officer, judicial officer, judge, grand shake, or whoever will put their seal to order the writ. So your affirmation says, I affirm and certify the facts stated above are true and complete and based on first-hand knowledge, and that I did serve the tenants at the last known address, and said tenants have 1. You check the box, have not responded and are in default, and the terms of default are all here because the whole process is written out on one page. Or 2, other. They responded but it was insufficient, or they've responded and see the attachment. I don't really know. This is where you're going to have to, develop. But you have to do your due diligence, and this is the evidence of it. So in our case, because there's no response, we check this box, I endorse it here, I bring it to the judicial officer. He may write more in here, he may write something else in here, he may write some other authorities or whatever, but at the end of the day, he'll put some type of seal on it, and now that'll be a perfected writ of waste levied against the prior owners, protecting this bill or this private security interest, just in case somebody wants to show up and divest me of the property. And all of that to be behind the UCC with the claim of assigned under the original patent title, so it can all be perfected and cured. But the only thing I would record on the county record, again, so that you understand, is this notice of non-acceptance of recorded deed. Because the only thing I want them to do is to force the indexing. Because I know under the non-acceptance of deed, they have the authority to make the grantor and the grantee the same as far as the indexing. And I can use this deed to reference the UCC filing that gives the substance and the basis and the cause of action for which this deed or this act or this judgment was recorded and acknowledged in the record. So I hope that makes sense, and I want to encourage everybody to start a membership on the website, thctrust.org. As you see, we've done a lot of good work. I've been in the background working on things. So I hope you enjoyed this video, and I'm out of here.